case concerning James Coffey before the Hamblen County Sheriff Department Civil Service Board. Mr. Coffey has filed a motion for application for citation of contempt, or in the alternative, request for a hearing. I'm not sure there's any factual issues here, are there? Does either council want to say anything?
I don't know that there's any factual issues either, Mr. Chairman, other than the ruling was issued from, I would say from the bench, but from you all the day of the hearing on the 15th. An order was entered just recently, I think on the 16th. The reason I went ahead and filed this motion was because the suspension was issued on November the 18th, and under the Civil Service Board rules, it requires that if a request for hearing be made, that it be made within 10 days from the date of the adverse employment action. So that's why I went ahead and filed that. Obviously, it's our position that the board ruled that Mr. Coffey was to be reinstated with back pay and benefits. The suspension for indictment was not anything new that was taken into account. In fact, it was discussed in testimony that the indictment was pending, and there was no request by the Sheriff's Department at that point in time for the board to take that into consideration as to whether or not that would be considered in his reinstatement. Therefore, it's our position that this should not be a new employment action. In fact, it was considered as part of the hearing, and whenever the board made its decision with back pay, although it says that the letter from Sheriff Jarnagin says that there was a reinstatement, there may have been administratively, but he was certainly never placed back into his position as jailer or worked any additional shifts. We simply received this letter, and he's been out of work without pay since. And speaking to Mr. Capps on behalf of the Sheriff's Department, I have suggested to him that if the suspension occurs, that if it occurs with pay and benefits, I don't know that there's any damages there, but that's not the case currently, and he is suffering damage because he's not being paid. Mr. Capps, in his response to my motion, pointed out that he's not disqualified from being a jailer simply because this indictment is pending. There has to be a conviction, and in fact, Sheriff Jarnagin testified during the hearing that this simple assault indictment is the equivalent of a traffic ticket, and that was his testimony, and he agreed to that. And so we're asking that if there is to be a suspension, that it be with pay, but what we're asking for is reinstatement from what the board ordered. And if Sheriff Jarnagin and the Sheriff's Department is not going to comply, there is a procedure under the Civil Service Board rules that says that the board is under a manifest obligation to apply to the county legislative body for a citation of contempt, to the Circuit Court of Hamblen County for a citation of contempt, to bring him into compliance. So that's what we're asking the board to do, is to enforce the order that is already made. And you know, if the Sheriff's Department wants to pay him while he's under indictment, we would certainly consider that as a compromise.
May it please the board, we certainly understand Mr. Coffey's position and understand Mr. Gibbons' argument. I think there's probably such a thing as being too optimistic going into a hearing of the type that we've had here, and I think the sheriff was very optimistic about the likelihood that Mr. Coffey would not succeed in his appeal. Therefore, the idea that he would be put back to work as a jailer was not something that he seriously considered at that time. We contend that this is not contempt, that in fact Mr. Coffey was administratively put back to work and then he was suspended, and that this action is a separate act of the sheriff about which they are now complaining. And we certainly agree that they would have a right to have a hearing on that, but we certainly say that because of the circumstances, insurance for one thing in particular have conversation with the insurance company, they're certainly not in favor of our putting Mr. Coffey back to work while he is under a criminal indictment. I trust that there are ways that the criminal indictment can be expedited in some fashion, or somehow that a criminal matter can be resolved to Mr. Coffey's satisfaction that would allow him to be put back to work. But we certainly say we're not in contempt of the board. We have a situation that the board really, and we could have and should have possibly considered it, but I say, frankly, the testimony elicited from some of our witnesses was not expected, to put it mildly. And so we would say that we certainly have a right to have a hearing, and but we're not in contempt on this particular action.
Okay. Okay, I think the board should first address the issue of the contempt, whether or not there's contempt. So again, we'll do like we did last time, that I'll give my position, then the other board members can give their position. I actually did some research on the elements of contempt, and found a case that says there's 4 elements. One is that there must be a lawful order. The order must be clear and unambiguous. The individual must have violated the order, and the individual must have acted willfully. We did enter an order that overruled the termination of Mr. Coffey, and ruled that he should be suspended for 60 days. The issue before us was whether the sheriff was correct in terminating him based upon the grounds set forth in the letter that the sheriff had given of termination. Those grounds did not include the indictment. Basically our ruling was that he'd be reinstated. We reinstated him. I don't think the sheriff had to do anything. So I think he was clearly reinstated. I don't find that the sheriff technically violated our order, which is the issue. It's not whether he should have done this or shouldn't have done this. On this issue, it's not. It's whether he violated the order that we entered. We reinstated Mr. Coffey. He was reinstated, and the sheriff chose to issue a new, in my opinion, a new suspension based upon grounds that was not before the board the last time. So I don't find that there's any grounds for contempt against the sheriff. You two want to address that issue, whether or not you believe that the sheriff should be referred for contempt? Okay. Does that, I'm not sure, are you saying that he should be referred for contempt or not? Okay. 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 So the unanimous ruling on the board is that the sheriff is not in contempt. The next issue is, it appears from the motion you're requesting a hearing on the suspension. Are you wanting that today? I think the act requires us to have a hearing in 30 days, and you could waive that, but that's up to you.
No, I mean, I think we'd have to, I certainly have the sheriff here to call him as a witness, as well as other witnesses, if we're gonna go through this whole show again. I guess my concern is where does this end? And so if the board were to reinstate him, and Sheriff Jarnagin turns around, this is an employment at will state, and so if he turns around and says, I don't like Mr. Coffey's attitude, or I don't like the way he presents himself, and he again suspends him, what's the purpose of this? What are we doing? And so that's my concern about this. And when you say that he's not in contempt, and that's the board's decision, is there any guess, remedy for him without having a hearing, to possibly be not reinstated, but to receive the pay that you all have previously ordered?
I mean, what we ordered before was that he be paid from the end of our suspension up until, I guess, the day he's suspended again, so I don't think.
That's my question too. I mean, Mr. Capps points out that an order is not, or that a ruling is not effective till the order, and so if the date of the order wasn't until December 16th, should his reinstatement and pay should have been through the date that the order was entered?
I believe that his back pay would be from the day the suspension, the 60-day suspension ended until the day that the sheriff suspended him again, whatever day that was.
Okay.
Which was close to the same day, I think, that.
I think it was the 19th of November.
It was effective the 19th. It was issued on the 18th. So.
It's the county's position that he should be suspended without pay. I mean, that's what the sheriff.
That is what I understand the county position to be without having Sheriff Jarnagin here testify. That's what I understood. Obviously, from the termination, the suspension letter, it was to be without pay. I can't argue to the contrary or tell the board anything to the contrary. But I will say this, I think that we would be ready to proceed, recognizing Mr. Coffey's position. I think we'd be ready to proceed very quickly to a hearing, assuming that the board can accommodate that.
Oh, and that's what I'm saying. I mean, we obviously do want a hearing, but where does it end? And that's what I'm saying. So if the board reinstates him again, and Sheriff Jarnagin changes his mind and he decides that he wants to fire him again or suspend him again, what's the purpose of that for us to continue doing this? At some point, there has to be some finality. The board has to enforce the order that it puts down, and not let the sheriff's department thumb its nose at those orders. I mean, he can continue to do this as long as we want to go through the procedure of doing that, but at some point in time, there has to be some finality to this. And so I would request a hearing, and we will have to take under consideration whether or not we appeal the Civil Service Board's decision as provided within 30 days under the UAPA, whether we go ahead and do that to Chancery Court, I think is our remedy. But I understand your position, and we can get together on a hearing date if you'd like at some point in time. If we just, you want to just do that by email, circulate that?
That's fine, then I'll contact the other board.
Okay.
But, I don't know that we have the power to tell the sheriff that he can't take what he contends is disciplinary action against an employee going forward. I understand your concern.
I think you can. I mean, that's explicitly what the rules say, is that you don't have that inherent authority to enforce your orders, but the county commission or circuit court, you can apply for that to enforce your orders. And so, as I said, he can sidestep that if he continues to choose to do so until he's brought into compliance through a contempt petition. And so that was our remedy, and that's what we've applied for.
Of course, we ruled that
I understand.
he did not violate our order.
But it was the contempt, I mean, the indictment was a known issue at that time. It was not brought up. It was never any mention that that would be grounds for a subsequent suspension. It's not provided for in any sheriff's policy that I'm aware of. It's not been cited to by Mr. Capps. In fact, in direct contravention of that, it says that he can continue as a jailer. So there's really no grounds to substantiate that, but we'll address that, I suppose, in the next hearing.
I think that would be the issue for the board at the next hearing, whether if someone's indicted for misdemeanor, is that grounds that they can be suspended without pay. And I will point out, you said that the assault's the same as a traffic ticket. It's technically not. A traffic ticket, you can only be fined. An assault, you could be sentenced to 11 months, 29 days in jail for an assault. So it's not technically the same as a traffic ticket.
Well, I'm certainly no criminal lawyer, but I do think that a traffic ticket, reckless driving, anything of that does carry with it the potential punishment of 11, 29.
Well, reckless driving does, but not a typically.
They're all misdemeanors.
Yeah,
no
it's a
doubt.
misdemeanor, but it could carry a lot. Is there anything else that needs to come before the board today?
Not that I'm aware of.
Let me just say this, I would hope that y'all could find some common ground, that somehow this issue could get resolved before it comes back to us. If he's continued to be suspended without pay and that goes on for some period of time and these charges get dismissed or he's found not guilty, I could see the county having a lot of liability in this case. And that, maybe I shouldn't have said that, but,
Well, we've
but
certainly
it
discussed
could,
it as
and
well.
I would just hope y'all could resolve something, but that's up to the county and Mr. Coffey. And if you don't, we'll hear it.
Thank you for your time.
Thank you.